you understand that people give out pineapples as housewarming gifts. Probably it's related to some extent to the whole giving out pineapples to let the other people in the neighborhood know you're down to fuck them.
Well, I mean, I've done it.
Okay? I was gonna say, buddy. Like,
no,
jeez, but
not
like you just go knock on it. You want to fuck?
Hey there. I just want to let you know that I'm 3 doors down and I'm DTF.
That voice does not belong to somebody I ever want at my door telling me they're DTF. Oh, that is not the voice of someone. Like, what's your name? Bob. What do you do, Bob?
I'm Bob, and I'm here to fuck.
Yeah. What do you do, Bob? Hit the cervix. Oh.
Yeah, college they used to call me Miller Time because my dick is roughly the size and shape of a beer can.
Oh. Oh, my God. Crack open a cold one and call my urologist.
Please tell me the audio is on for this.
Oh, yeah. I turned it on the moment we started talking about pineapples and swingers. We'll go silent again, like during the 30 seconds before the stream actually starts, because that's when I'm going to hit the record button over here.
Thank God.
So that I can make it a thing for the podcast without this conversation being a part of it. Like, I'm going to separately download this conversation and put it on Patreon or something.
Oh, please do. Yeah, So that means that Dave and Headfoxen are listening to all.
Oh, yeah, like them and the other dozen people in the chat right now. Yeah,
there's a dozen people in the chat. I don't see a list. Oh, there we are.
Yeah.
Hello, people.
Remember what you told me, buddy. I have to remind you it's a podcast.
Right. Don't acknowledge the audience. Just talk to you. This is a talk show.
Look, they're just in the corner of the room intensely watching. They like to watch.
You like to watch? Want to come over to my place?
No, Bob.
Listen, I mean it. I just leave the door open.
Just say, I'll just be there naked, spread eagle on the recliner. Walk in, take a right, bathrooms down the hall.
Help yourself to anything in the fridge. It's all going to go bad tomorrow anyway.
Except you may not want to eat that whipped cream. It's been places.
But let me tell you, when I call it whipped cream, I know what I'm talking about.
Yeah, I made it myself. God, that'd be the scariest phrase to ever hear in relation to whipped cream from your neighbor who introduces himself as being the guy who's DTF. I made it myself.
Well, it's not difficult. You just get yourself some heavy whipping cream and just go to town.
I don't think anybody wants to go to town on your cream, Bob. I could be wrong. There could be plenty of people who want to go to town on Bob's cream.
So far, Bob's success rate has not been good.
Bob is now banned from the Walmart.
But oddly enough, not the Target.
Not Target is classier. I need to send a message to my children. Be like, bring your father a drink. And see if any of them do so. Don't come back to the Woolworths. Oh.
Where will I get such fine deals, though?
There was, I forget what movie it was, but there was a movie out there, and it was like, and you're banned from the Woolworths.
That sounds like a Coen Brothers line.
It may have been. Yeah, I'm hearing, "Oh brother, where art thou?" So
that sounds right.
Yeah,
I mean, even if it's not true, it sounds right.
Like I could definitely see that line being said in that movie. Oh, my foot is swollen. It's big and red, like Santa's penis.
Go on.
I can't think of a rhyme with penis.
You can't think of a rhyme with red?
I wish I was dead.
Sometimes I wish you were too.
All right, radio silence, 30-second countdown. Fuck. I have completely I'm like radio silence, 30-second countdown, and now I don't know where the fuck my mouse is, and that's gonna make things interesting at some point.
Hey, are we using real names here? Because I can do whatever.
You can use whatever names you want. Okay, 10 seconds.
What are you gonna do?
I'm gonna use Boozy.
Okay.
Hello, everybody, and welcome back to episode 20 of Boozy's Legal Funhouse. I forget what I fucking named it. It's right there on whatever your podcast app of choice is. I'm certain that you can see the title. It may actually change between now and when I post it, because I am, as we have discovered, just a complete layabout when it comes to these things. I am your host, the Boozy Badger, Boozy Barrister. With me tonight is my oft-times compatriot, Buddy Goodboy Esquire. That's right. We don't use our real names. We're cartoon animal lawyers. Welcome back. It has been a while. It has been since I think the last episode went live in like July. And before we get into tonight's episode, a spooky-themed one about the law and ghosts, I feel I do owe you a brief explanation for the long hiatus. See, if you are watching our live recording over on twitch.tv/boozybadger, because this is recorded live and edited very little before we put it up, because fuck it, I ain't got the time. You will know that typically we do this in the Badger Studios. Well, the Badger Studios is actually a converted room in my basement, which has no air conditioning and high humidity, and this summer in my neck of the United States was just absolutely fucking miserable below and above ground. So, to keep myself from overheating and the melting down of my equipment, which, let's be frank, is more important, you can buy a new Boozy, but gaming computers are hard to come by. We had to move back up to the bedroom, and for the past 2 to 3 months, I have been streaming on the game streams from the Badger bedroom, which is fine. But I have children, and children don't respect podcasting rules like no background noise, please stop playing with that toy, and we can't watch Thomas the Tank Engine. Hence the reason for our hiatus. However, things have cooled down metaphorically, if not literally. And we are back in the Badger Studios this week to start back up with our weekly posts of the podcast. And before we get going with that, I do actually need to read off the names of our Patreon supporters over at patreon.com/Lawyers and Liquor. The wonderful people who give me money. This is going to be much harder than I thought it was because I have lost control of my mouse. I don't know where it is. I cannot see the pointer. It has completely disappeared, and I don't know. Okay, well, I know where it is now, and now I can't do anything else. God damn it. This is why I tell people that, like, letting me do things is a bad idea. Like, it's no shit. I've completely lost control of the mouse. I don't know what to do here. God damn, yeah, like recording live, everybody. It was working fine right before I was getting ready to take it on stream. Well, you know what? My Patreon supporters know who they are, and they'll love me anyways, right? God, I hope so. We need your money. But you can become one of these lovely people whose names, if I was technologically competent, I'd be reading off right about now over at patreon.com/lawyersandliquor. Tonight's topic is indeed going to be month appropriate. We are talking about spooky happenings and the law. Specifically, tonight, we're going to be talking about contract law and ghosts. I am, as you know, your host, the Boozy Badger, Boozy Barrister. Buddy, introduce yourself.
Hi, I'm Buddy Goodboy. I am a transactional lawyer turned attorney editor. So I just recently switched jobs, so I'm not quite sure how to introduce myself anymore. I've been practicing attorney for the last 7 years, and I'm not a litigator, so I've got a realm of different experience from Boozy here. Very few ghosts, have had a few time travelers. A couple of people abducted by aliens, but...
Okay, somebody tell me if there's a way to get a mouse that is frozen moving again. Because, like, I really want to go through, like, we have articles and everything, and I can't figure out how to, like, change the article stuff. I don't know how to do.
You don't know
this.
your keyboard shortcuts?
Like, how do I switch from one tab to another tab in Google Chrome?
Shift tab. No, sorry, Control tab.
Wait, does that work?
It should.
Yeah, it's not working.
Control tab goes forward, Control Shift tab goes backwards.
Yeah, I got news for you, buddy. It's not working. As a matter of fact, I can't even tell if my computer is frozen or not. Yeah, it's not frozen, but now we have a different issue. So let me very quickly, I guess I'll just do the news, because it's time for our legal news roundup, which probably be a lot more fucking helpful if I could read, the legal news that is part of the roundup. But let's start with a Reddit thread chronicles the worst experiences during law firm interviews. A recent Reddit thread was started where somebody, I'm assuming a law student, talked about their experiences during law firm interviews and how those were just apparently horrible. Things were said in there, like one partner said, "What is your hobby?" And the person said, "Golf." And they were like, "I don't like golf." And then they sat there quietly and stared at each other. Another comment was, "I am detailed oriented and meticulous." And then they put periods after each of their bullet points. So the interviewer, as every lawyer who is pedantic does, did nothing but spend the entire interview period commenting on how they fucked up their resume. And then at the end of the interview, I loved this, said, "Well, at least you were consistent with your error." Another interview took place where a managing partner of a firm interviewed with somebody for a possible associate's position, and then decided that was really therapy and spent the entire time venting about how much they hate their job and how miserable they are. Another interviewer had a normal interview up until the end of it, where they told the female applicant they should smile more and be peppier.
Did you hear my eyebrows raise right there?
Yeah, I heard that, like, audibly, and the people who are listening in, they heard those eyebrows just pop up. It was like, it was great. Trust me, the sound effect was amazing. The one I'm not going to add in post whatsoever, which would be like a little slide whistle. Everybody has bad interview stories. Like, it's almost a rite of passage for attorneys, that when you're coming out of law school and you're looking for a position, you go to these interviews, sometimes several levels of them, and you're questioned about your experience, why you want to practice a certain type of law, are you a good fit at the firm's culture, and things like that. And we all have horrible interview stories from that time period. Buddy, what's yours?
Oh, let's see. This one was a pre-recorded interview, so one I hadn't had experience with, but this was recent. I was asked to record a short video explaining why I wanted to work at this company, and I got the name of the company wrong. So, fortunately, I was able to crash my browser and restart. So I don't think anybody noticed because I got the job.
Okay, so here's an interesting fact on my mouse. Yeah, because I know that everybody is tuning in to listen to me talk about my tech support issues. I found the button that makes it stop changing color.
Good for you.
Haven't found the button that makes it because it's a wired mouse. It's a good wired mouse, but I haven't found the button that makes it fucking work again. This is gonna annoy the shit out of me. Because like now I'm sitting here, and like people are going unplug and replug, and I'm like, that's how we lose access to my stream. Everybody, like, is this the mouse that I'm about to unplug? Yeah. No, that didn't do anything. Okay. So that's fun. This is how we live now. My bad law firm interview story is right out of law school. I interviewed with a criminal defense firm, and I was about 3/4 of the way through the interview, and they're like, "We think you'd be a great fit for this firm. We think you'd be a wonderful fit." So there I am interviewing for this firm that decided I would be a wonderful fit, and they brought in the managing partner who sat down, looked at me, and said, well, everybody's impressed. I got one question to ask. I see here you say you have children. And I said, yes. And he said, the majority of our cases are defending people who molest children. And I said, well, thank you for your time. It's been a great interview. Do you mind if I take some of these? Can I have this mug?
You do get some good swag from interviews, though.
Yeah.
I did wind up with my first job at a law school. I wound up getting the job, and somebody had left a Liberty University College of Law coffee mug in the office. So obviously I stole that. And I like to think that every time I drink out of it, it gives a Falwell a twinge.
We have a mouse again, by the way, for all of our listeners who aren't watching this live. By the way, I'm sorry if you're listening to this later. If you're not here live, I am sorry for the quality of tonight's episode. Just give me some leeway. It's the first one back after like 2 to 3 fucking months. It's been a weird goddamn year, folks. So
understatement of the year.
Now that I can actually show it, let's go to our next story for tonight. From the ABA Journal, 1/3 of Americans have decided it might be better to do away with the Supreme Court of the United States if they don't like the rulings. From Deborah Casson-Wise, the Annenberg Public Policy Center of the University of Pennsylvania released poll results last Monday for a poll conducted in September, just after the Supreme Court refused to block a Texas abortion law that bans abortions after 6 weeks of pregnancy. The poll asked 2 questions: whether respondents agreed or disagreed with the statement, if the Supreme Court started making a lot of rulings that most Americans disagreed with, it might be better to do away with the court altogether. 34% somewhat agreed or strongly agreed with that statement, an increase from 20% in 2019. The poll also asked people to agree or disagree with the statement, when Congress disagrees with the Supreme Court's decisions, Congress should pass legislation saying the Supreme Court can no longer rule on that issue or topic. 38% agreed strongly or somewhat with that statement. Kathleen Hall Jameson, director of the Annenberg Public Policy Center, said, respect for judicial independence appears to be eroding. The thing, I mean, you know what, buddy? I'll let you voice your opinions first. 1/3 of Americans are fine with the idea of abolishing the Supreme Court of the United States. or the legislature stepping in to limit their ability to issue decisions if they don't like their decisions in a certain area of law. Thoughts?
I'm going to play devil's advocate. I think personally that the way the questions were phrased are kind of leading, honestly. So I'm not sure that that actually reflects what people actually think. But having said that, I mean, if you go back to Marbury versus Madison, the Supreme Court's ability to rule on constitutionality was a power grab on their own back in the day and had no basis in the Constitution. So technically, we've basically just been letting them do their thing because it's worked so far.
I mean, like, I once said we're going to take a stroll down Precedent Avenue, where there's all these wonderful precedents as statues on the side of the road. Brown v. Board, Roe v. Wade, things of that nature. Oberfelge, all of them lining the road, showing how the Supreme Court, having the independence to rule on something that may not be politically expedient, can further the causes that we want furthered. But at the same time, I also say there's that little offshoot of Presidential Avenue, don't go there lane, where we have shit like, Dred Scott.
Right.
And the simple fact of the matter is the idea of the judiciary being an oversight of both the executive and the legislative branch, having adherence to the Constitution, or at least the prevailing interpretation of the Constitution at that time, is a double-edged sword. You want an independent judiciary. You want the judge who was appointed or who was nominated by Donald Trump and confirmed by a Republican Senate to no longer be beholden to those interests. The problem is when we have people who arguably are extreme ideologues taking the bench, who seem to be appointed as almost single issue appointees to further a political agenda and show no indication of asserting their judicial independence now. When John Roberts was appointed as Chief Justice by Bush, I'm old enough to remember a lot of people weren't happy. And over the years, John Roberts has become the moderate vote on the court now, which it pains me to fucking say that too. I'm not saying John Roberts is a great man. Rah, rah, sis, boom, bah. John Roberts is like, I would like actual legal cover for destroying the institutions we love, not just, I kind of fucking wanna. So
these days I'll take it.
Yeah. And to be honest, it is a double-edged sword. If we, constitutionally, in the wake of Marbury, which Marbury v. Madison was basically the Supreme Court saying, yeah, we can overrule Congress. we have the ability to say Congress acted outside of its authority. But the concept of Congress coming back and overruling the Supreme Court, like that, not simply by drafting a law that is constitutionally valid, which they always have the power to do.
Right.
I mean,
that's always been acceptable behavior and has been done on multiple occasions. So
yeah.
No complaints there.
That, as a matter of fact, that is a typical response a lot of times when the Supreme Court overrules a congressional act that people really want to see by saying it's not constitutional. The response is Congress goes back and drafts a version of the law that will pass constitutional muster if appealed up to the Supreme Court that resolves those outstanding issues. But having Congress say, yeah, by the way, Supreme Court, we're going to make a new immigration law, and you don't get to review it. You can't say anything about it. You have no power to review and say whether this is constitutional or not. On one hand, it sounds great. It really does. Because
it sounds great if you're on the side that's winning.
Yeah, exactly. There you go. That's the point. It sounds great if you want to craft a very permissive immigration law that Congress or that the Supreme Court may strike down. It sounds fucking terrifying if the people proposing the agenda and drafting the bills and with the majority are people who, you know, want to deport everyone who can't show their great-great-grandparents were citizens.
Well, that's me out.
Yeah, I mean, that's the issue. That's why that worries me. I don't think we need to limit the authority of the Supreme Court. I think what we need to do, and this is my opinion, just my opinion, a better course of action, expand the court. We chose an arbitrary number of 9 around the beginning of the 20th century during a Judiciary Act. And the reason it was set at 9 was at that point in time, there were 9 federal circuits. And at that point in time, ostensibly, one justice was responsible for each circuit. It still sort of is like that. When an appeal comes up from a certain circuit, one justice reviews the appeal on it. But we can expand it. We have 13 circuits now, don't we? Like we're up to 13, aren't we? Or are we at 11? God,
We're
I can't
up to 13.
Yeah. So I see no reason why we can't say the number of federal circuits we have is the number of Supreme Court justices we have. One for each circuit, motherfucker.
That makes sense to me.
So it worries me a bit when I see that, because I hate to say it when I hear the majority of Americans believe, because I'm like, the majority of Americans don't get what's happening. Like, eventually these people will die. Like, Clarence Thomas ain't living forever. And if we
Keep
can't
saying it.
Yeah.
Keep saying it, it'll happen.
No curse on Justice Thomas, although I'll never argue for, like, that'd be great. Like, a year from now, I'm arguing in front of the U.S. Supreme Court, and Thomas just leans in and asks one of those rare questions, and all it is, are you the cartoon badger who said I was going to die? That worries me. That concept worries me. Because there is a reason that the system is in place. And I'm not saying the Supreme Court gets it right all the time. They don't. I disagree very strongly with a number of Supreme Court opinions. And I do think that the current politically balanced makeup of the court is extremely worrisome. But I am a judicial purist in that I believe that once you are on the bench, you are no longer bound by, and should not be bound by, your personal political considerations. Your job is to, with a learned hand, expertly apply the law to the facts and come to the ostensibly correct legal determination. I wish we had more people on the federal judiciary who felt the same, although I also want to point out some of the people on the federal bench who were rejecting Trump lawsuits were Trump judges.
Yeah, which I have to say, I really respect the... I hesitate to call it guts, but at least moral fiber enough to recognize their own judicial independence in a situation like that, and that they don't have to continue obeying the orders of the person who appointed them.
Well, that is the concept of judicial independence. That is the entire concept in one go. For our last news article tonight, also from the ABA Journal, a judge on New York's top court has been banned from the courthouse after refusing to reveal their COVID-19 vaccine status. Only one judge in the entire court system for the state of New York has refused to comply with the mandatory COVID-19 vaccine mandate. While the court would not reveal who that judge is, an anonymous source has identified her as Judge Jenny Rivera, who sits on the New York State Court of Appeals, like your Supreme Court in any other state. Except, I think like the New York Supreme Court is their trial courts. I don't fucking know, man. New York's weird. Like New York in Louisiana could just...
You could have just said New York is weird and left it at that.
Yeah,
Yes, their Supreme Court is the trial court. Then Court of Appeals is their version of their Supreme Court.
Well, it's like California. Whenever I see there was something that was based in Pennsylvania. It was a movie or a TV show. I forget which one. But the seal behind the judge and the trial court says the Superior Court of the Commonwealth of Pennsylvania. And I started laughing because I knew exactly why they had fucked it up. In Pennsylvania, the Superior Court is actually our intermediate appellate court. It's the court between our Supreme Court and our trial courts. Our trial courts are called the Courts of Common Pleas. The Superior Court in California, where this was likely made and written and designed, like the props were designed or built, is the trial court. So, in their fictional universe, the Pennsylvania Intermediate Appellate Court was hearing like a murder case as a matter of first impression. It's interesting to me. It's a law geek thing. If you don't understand why it's funny, fuck you. Just take my word for it. One of us has a law license. Anyways, Rivera refused to report her vaccination status and didn't apply for either a medical or a religious exemption, and therefore will not be allowed into any court facilities, including her own chambers. The New York Law Journal described Rivera as a member of the court's liberal wing and the currently longest-serving judge on the State Court of Appeals. I love it. The New York State Court of Appeals spokesperson Gary Spencer told people, well, I can't talk about a court member's personal health information. I will confirm that Rivera will participate remotely during all in-person arguments, which tends to
pretty much confirms it.
Yeah. It says the last time that she was in person during oral arguments weeks ago, she sat apart from all of the other judges, which brings up an interesting question. Buddy, you it's been several years since you've done courtroom practice, right?
Correct. Yep.
Meanwhile, I had like a bench trial, a dispositive hearing, and preliminary objection arguments over the last 3 days. In a variety of cases. So I've been in court in person. And I can tell you the way that courts are now handling it differ, not only from state to state, but county to county, and in some cases, courtroom to courtroom. Our federal court here is, in my division, has a big sign at the door. It says, masks required to enter courtroom. And you walk in with the mask and you pass the bar, and then the judge says, okay, you can take your mask off. There are other judges. Today I was giving an argument because the president judge of our county has issued an order saying you have to wear a mask in court. I was arguing through the mask, and the judge finally just said, Mr. Badger, are you vaccinated? And I said, well, yes, Your Honor. And the judge says, please take your mask off. I cannot understand you. So it has been interesting to see how this applies. By the way, it is always fun during the first stage of the pandemic, before they shut down all the courts. I had one hearing at a local magistrate that I ran out to, and when we got there, there was a giant sign on the door that said, due to a reported COVID case, this court is closed until X date and all matters will be rescheduled. And it wasn't like a short drive. Like it was like an hour and a half drive to the court. So I'm sitting there. It's early in the morning. I got my coffee. I've driven a long way to the court. And I'm like, do I just want to take today off? Like, we're not off to a great start. Maybe I can just take a mulligan on it, you know? But... Buddy, I'll let you have. Do you have any legal COVID stories?
Well, I did have. Now, my most recent work experience has been for the last 3 years. I've been an attorney for a medical practice, working in their building. So, obviously, we've been required by the CDC to require masks in the building. So that's applies to everybody equally. I did have everybody working the front doors enforcing this mask mandate say that if anybody tries to hand them a card that says that they're not required to under the ADA, the Americans with Disabilities Act, or if somebody claims that HIPAA says that they can't ask about their vaccination status, bring that to me because I want to keep a copy.
Did you have like a Nerf bat where like they're like, the ADA means I don't have to wear a mask and you can't violate my HIPAA by asking me, and you were like taking the Nerf bat and like, no! No! Stop getting your medical advice from OANN. Newsmax is not a legal expert.
Fox News is an entertainment site, not a news site.
So, Oz to tonight's topic. I'm British. Oz to tonight's topic. As to tonight's topic, we are in October, my favorite month of the year outside of December. Unless you're going to the local, like, Target or something, then apparently we're already in fucking December and will be for the next 2 months. And then suddenly it'll be Easter. But we are in October, my favorite month of the year, outside of December. And the reason it's my favorite month of the year is it is a time I get to be spooky. I love ghosts. I love horror. I'm a bit of a scaredy cat. I like being scared. I like telling creepy stories, and I like listening to them. And I don't know, Buddy, do you believe in ghosts?
I don't personally, but I understand that you have ghosts in your house in the room that I slept in when I was there.
Oh yeah, the murder room. Like the real murder room, not like I jokingly call the studio the murder room because it looks like where you would murder somebody. But you're talking about the bedroom that someone was literally murdered in.
That's correct. That's exactly what I'm talking about.
Yeah. Yeah.
I didn't notice anything strange, but I was also really tired, so
like
I would have written anything off to sleep through it.
Like, I don't know if there's ghosts in my house. I have no idea. Old houses make noises, creaks, pops, blood-curdling screams of get out. All those are natural things when you have an old house.
Oh, that's good to know. I'm in the market, so I'll keep an eye out for that kind of thing, but I won't worry too much about it.
Well, buddy, we are attorneys. We are trained.
So you say.
We are trained to assess the evidence and the facts and draw conclusions based on the law and how it would apply, correct?
Correct.
So do you believe that courts believe in ghosts? Does
100%.
the law recognize life after death and haunting?
If the evidence is there, or if it keeps somebody from doing something the court doesn't want them to do, I would say that yes, they very much do believe in ghosts and life after death.
Well, let me ask you, buddy. You say if the evidence is there. What do you mean? What evidence? Like, hold on. Do I have to be like one of those fucking ghost hunting shows? Do I have to go into court and go, say, Your Honor, here's the EVP meter, and it flashes through all these radio networks, and it said, please help me buy 2 for $1 hot dogs. Please.
That would help.
like what evidence does it? What evidence habeas the corpus of the ghost?
Well, if I recall correctly, the devil could not be habeas corpus, so I'm not sure what spirits could be.
I like that. What Buddy is referring to is a while back. Some guy who was he was definitely in another worldly realm, decided to sue the devil, and essentially, what was the decision? I forget the name of the case. Honestly, I did
the name of the case.
Yeah, I didn't pull it, but it was a great opinion because it was like, while the devil may have gone down to Georgia, there is no proof he was domiciled there. Therefore, this matter is dismissed for lack of jurisdiction.
Right. It's actually a great case for explaining the long arm statutes of pulling out of state residents into specific personal jurisdiction with a state. So fascinating case. I definitely recommend you read it if we can remember the name of it.
Yeah.
We can edit that in, right?
Like, I'll put it in the show notes if
Yeah.
I recall, and I'll actually look for it after we're done recording and see if I. But that was a good one. I hadn't even thought of that one for tonight. We all know there's at least one case that every lawyer in the world knows, or at least in the United States, because it is what we call casebook law. Case books are these big books in law school. Here's the way that you learn the law, okay? There is no book of law. There is no giant tome listing every legal precedent and decision that has ever been made. This is not geology. This is not your high school history course with the horribly outdated textbook. The way lawyers learn the law is we are handed a literal book of cases, reported case opinions from all over the country and sometimes from out of the country, most likely England, and the English cases are great because it's like in 594 before the bench of the king, because there are all these old precedents that we call now black letter law, which just means it's something that is so fucking established you don't even have to cite it anymore. You can just say it is black letter law and everybody's like, yeah, no, he's right, it's black letter law. But these case books, they're just filled with these cases. And the way we learn the law in law school is there's assigned reading, and we read the cases. And we determine the facts, the holding, the analysis, the reasoning, all of those things. And then you go into your class, and your professor cold calls you because your professor's a dick and you didn't do the reading. And you are asked to recite these things, the facts, the analysis, the holding, the reasoning, the law, the rule that was derived from it. And then the professor will say, do you think that's correct?
It's important to note there is no correct answer for that question.
Because once you give the answer, whatever your answer is, the professor's going to turn around and say, okay, but what about this? Okay, but what about this? And will press you to explain, to make sure you're understanding the reasoning on why it should be reached, why it shouldn't be reached. And sometimes the professor will turn and pick out another unassuming person and go, Mr. Goodboy, do you believe that Mr. Badger is correct in his analysis?
And at this point, you freeze up, and whatever falls out of your mouth is going to be the next thing that they discuss. So, in this particular case, I would say, yes, I do, and then stop there and wait for him to ask why.
Yeah, why?
Because the correct answer to any question is always the answer to their question.
And then, well, what if? And then they pose a hypothetical. This is called the Socratic method. It's a pain in the ass. There's actually a book out there called 1L. It's about a person's experience at Harvard Law School as a 1L, your first year of law school. And in it, they talk about a campus tour where somebody said, and this is the Widener Library, named after the Harvard law professor who invented the Socratic method for teaching in law school. May he burn in hell. It's probably one of the best.
I have a name for my pain.
Yeah. So anyways, in this casebook, in one of these casebooks, is a case called Stambovsky v. Ackley. Now, if you are a reader of the Lawyers and Liquor blog that I had before I started doing a podcast, you may be familiar with Stambovsky. We spoke about it. Mr. Goodboy, would you care to recite the facts of Stambovsky v. Ackley for the class?
Of course. The plaintiff, Stambovsky, brought a suit to rescind a contract to buy a house after he discovered that the house was purported to be haunted, so the house would therefore have a lower property value than he was originally led to believe. Now, the fact that this house was haunted was well established in the community. It was on a walking tour of haunted sites of New York, so this was not something that that was unknown, but it was unknown to him at the time because he was not from the area. So now this is a condition that would impair the value of the property, obviously. But the issue at question is, are ghosts real? And does a haunting lower the value of a home enough to be able to rescind a contract to buy said home?
There's some additional facts that I always love. First, Stambovsky wasn't from this small town in New York. Stambovsky was from New York City. Personally, I've always felt, upon reading the case, that Stambovsky bought the house, decided he didn't want the house, and this was a way to get out of it. The prior owner had actually advertised the house as haunted and had been on radio shows and had written pieces for Reader's Digest and placed it on walking tours. It was a whole thing for the prior owner.
Yes, it was 3 decades worth of a thing.
And the case was actually regarding a contract principle called caveat emptor, which is Latin for fuck you. It is actually Latin for let the buyer beware, which means prior to entering into a contract to purchase goods, it is upon you to do all due diligence to discover defects. There are exceptions, of course, but generally that's the rule in a lot of transaction. And in New York at that time, it was the rule in residential real estate transactions. Let the buyer beware. The seller has no duty to disclose. Let the buyer beware. And this was a case that actually established to some extent that a known condition created by the seller must be disclosed to the buyer if the buyer could not reasonably discover it through due diligence. And did away with caveat emptor, really, in residential real estate transactions in New York. The known condition in this case was, to wit, the house was reputed to be haunted. And can anybody guess what Miss Ackley's defense was?
Oh, call it me, Professor. I am
yes, Buddy.
There's no such thing as ghosts.
Correct. And the court said, nope, there are. Right? That's what the internet would have you believe. If you actually Google legally haunted house, it's going to say, the New York courts decided ghosts are real. But that's not really what the New York courts decided. What the New York courts decided was that that specific person, the seller, could not argue ghosts aren't real. The seller, over a course of years, had promulgated for her benefit that the house was haunted, had placed it in magazines, had put it on walking tours, had gained some benefit from doing so. And the moment that somebody tried to use that as grounds to rescind a sales contract, she said, but ghosts aren't real. And the court said, no, we're not going to let you do that. You've spent decades telling people this house is haunted. You've benefited from it. You don't get to walk it back now. That's a concept known as estoppel. And estoppel means you are estopped from asserting an argument contrary to a position you have taken in the past that you benefited from. You can no longer say ghosts aren't real when for years you have benefited from saying ghosts are real and my house is haunted.
It's less that the court was saying that ghosts are real. It's more that they're saying you live by the ghost, you die by the ghost.
Right. What the New York court actually said was, Madam, as to you, this house is legally haunted. As to the next guy, maybe not. But as to you, this house is legally haunted. And the question is, what is the court's position on ghosts then? Because no court in New York has determined that ghosts are real, right? All they've really determined is you can't claim ghosts are real, get a benefit from claiming ghosts are real, and then seek to disavow ghosts the moment it stops being advantageous for you. That's the real holding of Stambovsky v. Ackley vis-a-vis, is there such a thing as a ghost? Well, we have done some research to see if any other court has addressed the question of whether or not ghosts are real. More specifically, whether or not ghosts are real when it comes to contracts. And by done some research, I mean, I read an old Harvard Law Review article and then read the cases that cite it, because that's really how you do legal research. No shit. You Google to see if there's something, like you use Law Google, who Buddy is now representative of. You use Law Google. I'm not saying the name of your company. You use
Thank you.
you use Law Google, you search for terms, you find them, and then you see who they've cited to and whether anybody's cited them.
Right. That's the whole point of the service. It's to make it easier to do this kind of thing. So this is not a shortcut or anything. It's
how you do legal
having
research. Yeah.
Can you imagine having to read every single case all the way through?
Yeah, like in the olden days when you did legal research, you'd go into the library, I assume with the librarian from the beginning of Ghostbusters, looking over your shoulder, and you'd pull out what was called a legal encyclopedia, and you'd look up the topic, and you'd find the state in there, and then you'd go to a reporter, and you'd read that opinion, and see who they had cited, and you go back, and then you would cite check. Like, yeah, there were little volumes that were like, these are the cases that were cited in these cases, and you would see whether that case had shown up in them, and it was a whole thing.
Yes, I've actually done it like that before, too.
Yeah, so as a matter of fact, when I was going to law school, they were still teaching that method. You had to learn that method.
Yep. I think I went to law school roughly the same time as you. We had to learn the same method, but like in practice, I've actually had to use that. For whatever reason, somebody forgot to pay the subscription to the legal database that month. So during the couple of hours that they needed to do, I was not off the hook. So I had to go to the legal library that they had in the building and then do my research that way.
Yeah, no, I've done it before. I think everybody's done it before.
Yeah.
Because there's some things where, yeah, it really is just helpful to have a legal encyclopedia. And legal encyclopedias can cost more on the research database than just the cases. But in doing so, I went through and I found a few cases, buddy, and I sent them over to you for a chance to review. And I'd like to talk about just a couple of them. This one right here from Nebraska in 1895. Miranda J. McClary et al. V. John S. Stull et al. Did you get a chance?
Year, 1895.
Did you get a chance to read this?
I did, yes.
Okay, so Lizzie Handley was an old woman. Lizzie Handley was an old woman with a lot of money. Lizzie Handley was an old woman with a lot of money and a will that left it all to a retirement home, like a care home, rather than her heirs at law. And of course, when the heirs at law found this out, they weren't happy. I'm going to read you Lizzie Handley's will. In the name of the benevolent Father of all, I, Elizabeth C. Handley, being of sound mind and memory and in fair health, realizing the uncertainty of this life, do hereby make and publish my last will and testament. Item first. It is my will and desire that after my death I'll be buried by the side of my late husband in Walnut Grove Cemetery at the village of Brownville in Namaha County, state of Nebraska, and that my executors hereinafter named complete the record upon the monument now erected on the burial lot, and to place at my grave suitable head and foot slabs. Item second. I give, grant, and bequeath unto my beloved nephew, John C. Ward, all of my books of every description, my gold watch and chain, and all of my other jewelry of every description, and such of my family pictures as he may desire. Item third. I do hereby give, grant, and bequeath unto the Home for the Friendless, now located at the city of Lincoln in the state of Nebraska, my piano and all of my china and tableware of every description, to be owned and kept and used by said home forever. Item fourth. Okay, I'm not going to go through like all of those. I am going to say she left all of her furniture to the Friendless House as well. All right. However, here we go. This is the important part. Item fifth. It is my desire and command that my executors hereinafter named shall collect all of my property, both personal and real, bonds, stocks, credits, goods, chattels, chooses in action, and everything of value, except such as are herein bequeathed as above set forth, and to sell the same at public or private sale as may seem to them to be most advantageous, and to convert the same into money as soon after my death as the same can be done without sacrifice, and now the proceeds of said sale to first pay all of my just debts, funeral expenses, and expense of my last sickness, and the expenses of administration, and all the monies remaining after carrying out the provisions of this will as set forth above, I hereby give, grant, and bequeath unto my loving family. bullshit. Unto the said home for the friendless, now located in the city of Lincoln, Nebraska. It is in this, my last will and testament, I well remember all of my relations, both near and remote. And as I am under no particular obligations to them or either of them, and desiring that my estate may be used for the very unfortunate class of persons who have a right to be admitted into said home for the friendless, I feel it to be my sacred duty to give all that I have left in this world to the home for the benefit of the poor unfortunate people who are cared for by this home, the grandest institution in the state of Nebraska. A lot of nice things said about the home of the friendless, but the important part is that last thing I read. That's the fuck you. That's the fuck you to the heirs. That is the, oh yeah, I remember all of you. I'm just not giving you shit other than my gold watch and chain and some family photos, and those only go to my nephew. Fuck the rest of you. So the family reacted reasonably and carried out her wishes. And by carried out her wishes, I mean they immediately upon her death said that Miss Handley was insane, and was not of sound mind, and that the will is the result of an insane delusion on her part, by reason of which she was altogether incapable of disposing her property, and therefore utterly void. The rule at law being that only a person who is of sound mind and not suffering a delusion such that it would make them forget about their errors or the nature of their assets can make a valid will. Well, what was this insane delusion?
Ooh.
Yes?
She made her business decisions by consulting a Ouija board.
Actually, yeah. That's actually exactly what she did. She was a member of the spiritualist movement and had made her business and estate administration by contacting the deceased with a Ouija board, who told her where to place her money upon her death and how to distribute it. I can see that.
To her credit, she didn't make a lot of money, but she didn't lose a lot of money either. Yeah, so
I mean, I'm just
debtor is reliable.
And she really, I mean, she sought out the advice of people who know. Well, how should I make my will out? I know. Sits down with the fucking Ouija board. Her heirs actually argued that the will was the result of insane delusions and undue influence from the other side, saying that she was unduly influenced by the spiritualist who was conducting these seances, and by the other side as a part of the insane delusion regarding her estate. So they asked the court to say, you know, ghosts aren't real. It's obvious that she wasn't in her right mind if she was believing that ghosts and the other side were telling her how to dispose of her estate. Buddy, what do you think happened?
Well, considering I read the case, I actually know what happened. But obviously, the relatives took this to court, said that she was non-compos mentis. Is that the correct term?
Yeah, non-compos mentis. It means not mentally capable.
But the court is forced to determine whether or not a belief in spiritualism does actually betray an unsound mind.
Well, more specifically, not a belief in spiritualism, but a belief that ghosts were telling her how to dispose of her estate. Because that really was the question. Is this person crazy for believing in ghosts? And how'd the court decide? Listener, how do you think the court decided? Shout it out. I'll hear you, I promise. All right, have you shouted? Okay. Well, the court decided. Yeah, the court decided that nothing in the will specifically referenced communing with the spirit of her dead husband or other spirits. And then said, and I quote here, "We find in the record no evidence tending to prove that the alleged spirits, through their communication with the testatrix, tended to prejudice her mind directly or indirectly against the contestants or in favor of the home for the friendless. In fact, any conclusion with respect to the substance, even of such communications, must rest entirely upon conjecture. Law, it is said, is of the earthy, and that spirit wills are too celestial for cognizance by earthly tribunals, a proposition readily conceded. And yet, the courts have not assumed to deny to spirits of the departed the privilege of holding communion with those of their friends who are still in the flesh, so long as they do not interfere with vested rights or by the means of undue influence seek to prejudice the interests of persons still within our jurisdiction. What does that mean? It literally means that the court said, we don't know if ghosts are real, but we're not going to decide that. If they are real, they got a right to talk to people as long as they don't unduly influence them. You know, if they don't fuck with the right that's already vested in somebody, that somebody already holds, who cares? So we're not going to throw this will out because she spoke to ghosts. You gotta love that. You gotta love the decision. We don't know if ghosts are real or not, but we're erring on the side of caution here. And the side of caution is maybe Grandma was talking to her dead husband who wanted her to leave it all to charity. We don't know. Essentially, the court punted it. The court basically said, we're not going to decide whether or not ghosts are real. We're going to say that if ghosts are real, why shouldn't they be granted the same right to talk to people and suggest things as we would to her nephew who got the gold watch in family pictures? As long as they're not fucking around with anybody else's rights, what's the problem? So they kicked the case. They held the will was valid. They allowed the charitable contribution. And it would not be surprising to me if somebody out there thought, well, obviously these are outliers. But oh, do you know about Texas? Apparently, in the early part of the...
You know about Texas.
Have you heard about this new Texas place? It's fucking insane! Apparently, in the early part of the 20th century, when spiritualism was big, there is a line of cases, and I'm only going to cite the two of them. There is a line of cases in contract law where people basically went to court to say, it was fraud. These people got me to invest in something. Each time it's fucking oil. Like, it's always oil. These people got me to invest in something by saying ghosts told them there was oil under their land. And ghosts aren't real. I want my money back. One of these cases, Burchill v. Hermsmeyer. Hermsmeyer. This is from Fort Worth, Texas in 1916. Decided in 1919 by the Court of Civil Appeals of Texas sitting in Fort Worth. In this case, the plaintiff, a gentleman named Hermsmeyer, apparently, entered into a contract with Belle M. and Edna Burchill in the Fort Worth Oil Development Company to recover the money that had been paid out for the development of their land. The land in question, they represented as having had a geologist who had looked at it and said there may be oil there. They represented that other companies may be interested in it. And then they said, oh, by the way, the ghosts told us there was oil here, so give us your money. Buddy, if somebody came to you right now and said, a ghost has told me there is oil under my land, give me the money to develop it, what would you say?
I'd say, give me a chance to call my attorney.
Give me a chance to call my lawyer. Well, then, you know what I'd say? Will the ghost submit an affidavit? What's the ghost's licensure like?
Yeah. Is this a ghost of a geologist?
So, how much money do you think you would give him?
Oh, not more than $100.
Not more than 100. But how much money do you think this person gave them in 1916?
Not enough to fill a briefcase, but enough to fill a lunchbox.
$10,000 in 1916 dollars.
Oh God, that's what, like $1 million today?
Yeah, but like more than likely. I mean, just more than likely. $10,000. So they sued. Obviously, he sued them. When the ghost done fucked up, they must have been talking about, Miss what's her name from the last case, Handley's piece of land out there in Nebraska. When it turned out the ghosts were just a little mixed up on their symbols that night. Maybe somebody drew a sigil wrong. Somebody lit a fucking tea light instead of a ritual candle. I don't know. But the ghosts were a little fucking off on their estimates because the amount of oil actually found under the land was surprisingly none. The ghosts were wrong. So, of course, Hermsmeyer sued them and said, by the way, it's fraud, motherfuckers. You fraudulently told me that ghosts told you there was oil under your land. I would like my money back now. The lower court actually agreed. The lower court said, you know what? Yeah, we're okay with that. We're fine. We're gonna give you your money back. This is some obvious bullshit, right? So the Burchills, who I'm assuming had spent the $10,000 paying those ghost consultants they got, then appealed, saying they should have been entitled to a new trial because sufficient evidence had not been made.
Sorry, 1 second.
It's okay. Had not been made on this. And the court in Texas took a look at it and said that they could not say whether or not the spiritualistic communications from the dead regarding oil were truth or false. They actually did state, in their opinion, there was considerable other evidence relating to spiritualistic communications as to the existence of oil underneath the lands in questions, and we perhaps notice the subject a little more particularly. As the Texas court said, we do not care to say that spirits from the great beyond may not visit and communicate with the living, nor that it is impossible for man's spiritual powers to be so developed and purified as to constitute a medium for communication with disembodied beings. For the phantasm of today is so often the reality of tomorrow. But these subjects belong to realms and powers that as yet must generally be classed as purely speculative, and not so established by evidences cognizable by the law, which we are required to administer as to be classed as facts, as among proving things. What were they saying? They were saying, we don't know if there's ghosts. we don't know. We're not sure if ghosts exist or not. We have no idea. Maybe they do. Maybe, it seems like fantasy today, but tomorrow, Ghost Jesus could tell us there's oil under the courthouse in front of 1 million people. Maybe ghosts exist. We're not going to touch it. What we are going to say is there's not enough evidence that ghosts are real that we are comfortable classifying an assertion that ghosts have told you there is oil under your land as an assertion of fact necessary to sustain the elements of fraud. So once again, another court came back and said, we don't know. We don't know whether ghosts exist or not. If ghosts existed, maybe you win. If ghosts exist, maybe you win, Mr. Hermsmeyer. Because if ghosts exist, and there's evidence that ghosts exist, then you could have taken that as a statement of fact. But there's not enough evidence ghosts exist. That means you should have been relying on statements, ghosts told me there was oil, sufficient to give someone $10,000. And this theme continued. You would think that that would be the only one from Texas where ghosts were telling people where to drill for oil. And, I mean, technically you'd be right, I guess. Because in Nurse v. State, this is a 1910 case, it wasn't oil. It wasn't oil. It was
cash, which I found odd.
Yeah. It was $20. Like he's like, give me $20 and I'll tell you where the ghosts told me there's money on your land. That's exactly what the case. Hold on. Where upon trial of swindling consisting of false representations by defendant upon the ground he could find buried treasure by communication with spirits and by which he obtained the sum of $20.
Okay, let's pause for a moment and just enjoy the use of the word swindling in an actual court case. Oh, I love it. Hits me right where I live. Now, the thing that gets me about this case is not that, that this guy claimed that he could talk to the spirits and find where money was buried and thereby got $20 for the attempt to do so. The thing that gets me about this case is that he was right.
Yeah, he found the money. Like, no shit. Like he said, the ghost told me where to find it. And then he went out and found it, and they still convicted him of swindling, saying, ghosts aren't real. Ghosts aren't real, and convicted him of fraud. Convicted him of swindling. Because he went to somebody and said, if you give me $20, the ghosts have told me where there is cash on your land. He found the cash. It was like $42, some gold coins and shit. You know what got him caught? The reason that he got caught. Listen to this. The gentleman who gave him the $20, Mabry, said in court, I am not complaining because he got my $20. But I am complaining because he came back there and stole the money after he found it in the hole. If he will bring up that bucket of money that was dug out of the hole, I will dismiss this case. I will take chances on it being money. Jim Nurse did not deceive me or misrepresent anything to me about money being buried in my yard because the money was there. And he dug it up and had it buried in the yard so he could come back that night and steal it. That is how they convicted him. That was his conviction. Was, I'm not mad that he took $20 and told me ghosts told him where money was on my property. Because he found the money. He was right. There was money. Maybe he put it there. I don't fucking know. But I'm a little pissed he came back and stole the money. Did the ghosts tell him to do that? Because them ghosts sound like assholes.
Yeah, that's not a swindling thing. That's just theft. Probably of his own money, because he probably buried that there himself.
The court came back and said, we are of the opinion that the evidence does not support the conviction. Which, I mean, like, that's about as clear as you can get. Ghost told me there's money on your property. Really? Yeah, give me $20. I'll tell you where it is. And he gives you the $20 and you go out there like, money's right there. They dig it up. He's like, holy shit, there's ghosts. Yes, there are. Yeah, that's pretty good evidence right off the bat, right? Like, I know that as logical people, we can all sit here and say that it's not evidence that there were ghosts there. But he just said, maybe he put the fucking money there himself. Matter of fact, he probably did, so he'd get $20. Maybe it's all counterfeit money. But the court actually then went on to say, if the appellant made the representations that he was a spiritualist and could talk with spirits, this matter raised the question about which this court does not feel called upon to discuss or decide. The question of spiritualism and talking with spirits is a matter about which there is no evidence. We read much and hear more about the question of spiritualism and what it means, and about which the world may be more or less credulous or incredulous. And there is something in the New Testament, always a good sign, when the court of law is going to the fucking Bible, to the effect that spirits shall be tried as to whether they were false or true. Glendower, in one of Shakespeare's plays, once again, always a good sign when a court's going to fucking Shakespeare for their legal principles, said, I can call up spirits from the vasty deep. It goes on like this, but it literally comes down to the fact is uncontroverted whether he talked to spirits or not, that he found the money. So the court, once again, said, we're not deciding whether ghosts exist or not. Maybe they do. We don't fucking know. What we do know, he said he'd find the money. He found the money. Doesn't matter whether the spirits told him where it was or not. The deal was $20. I'll find you money. Problem is, the state tried him for fraud. The state should have tried him for theft. So they reversed and remanded it, saying the state had failed to prove their case. Buddy, what are your thoughts?
Well, the whole thing could have been avoided if the trial court actually tried for theft conviction. But I do love the fact that none of these courts want to be wrong about the existence of ghosts,
right?
So they're covering their own asses.
Right, like all the courts, like maybe fucking ghosts are real. Maybe they are real. We're gonna look really fucking stupid if tomorrow ghosts are real. We're gonna look dumb. Like 50 fucking years from now, somebody's gonna have evidence of ghosts, and we're gonna look like fucking lunatics. So, ghosts aren't real. Ghosts aren't real. And then there's going to be a ghost lawyer arguing a case in front of the Supreme Court, referring to how short-sighted and close-minded we were.
You know, I gotta respect their openness to being wrong. Their openness to the possibility of life beyond this. Is what we know.
Let's just be honest.
Well, let's be honest. They're trying to cover their own asses.
Yeah, and not only that, do you want to be known as the court who's like, you fucking hear about Jim? What? Judge Jim. You hear about Judge Jim? What happened with him? Motherfucker said ghosts are real. What? Motherfucker said ghosts are real. Like every lawyer going up in front of him afterwards. The spirit of the law, Your Honor. Oh my God, how did they all miss the spirit of the law pun?
None of them said anything about having a ghost of a chance.
Right? Super serious.
This argument is just beyond the pale.
Oh. So that is kind of the issue at law. You'll hear a lot, especially if you're listening to this and you're looking at legal things this Halloween season. You will be hearing about Stambovsky v. Ackley and how a court has held ghosts are real, but that was one case, and they were only real for one property, and only when that one person said they weren't. What's the actual state of the law when it comes to ghosts and contracts? We don't fucking know. We don't know, and we're not going to risk it.
And we're not going to risk the chance of being wrong, so we're not going to say anything.
You know, to the extent ghosts do exist, we think they should be able to talk to their dead wives and tell them to leave money to a fucking charity. Yeah, we're fine with that. We're okay with Mr. Handley coming back from the dead being like, leave the money to the home for the friendless.
You would not believe the things your nieces and nephews say about you.
Except that John nephew. Good egg, that kid. Give him the watch.
He seems like he's a good one. We should keep him in the will.
Just for a watch, some china, and whatever pictures he wants, though. Don't go overboard. He's still Ethel's kid, and Ethel's a bitch.
That really brings up the question, if there is life after death, what do you do in cases of life appointments?
Oh my God. Well, I mean, technically they would end. When the life ends.
True, yes, they would end, but that calls into question, is there a distinction between different phases of life, existence rather?
Oh, buddy,
But
did you just give us the topic for the next Legal Funhouse?
I think I may have.
Did you just say that the next Legal Funhouse is going to be a discussion of what does life appointment, life estate, till death do us part, and lifetime obligations really mean?
Yes.
By the way, I appreciate the pregnant pause there. Yes.
I thought it was a rhetorical question.
So, folks, we are back. We are back on a weekly basis. So thank you so much for tuning in and sticking around and waiting. I appreciate your patience as I get shit in order over here. Next week, tune in for a discussion of when does life end legally? On Boozy's Legal Funhouse, the Halloween edition. My guest tonight has been Buddy Goodboy, Esquire. This is your cue to say something.
Yes. Check me out on Twitter if you like. If not, perfectly fine. I'm not in it for the followers. I'm here to make friends.
Actually, I forgot about something because my Patreon supporters get a chance to submit questions for us, and I was going to end early, but we need to go through these.
Oh, yeah. Of course.
Dozer has asked, what are the legal ramifications of pretending to be a ghost in order to encourage someone to sign or break a contract?
Well, if I remember Scooby-Doo correctly, a bunch of kids and their dog come against you.
Actually, it is it's interesting you say that because the part of the question I didn't read just reads Scooby-Doo style. I mean, we have like fraud probably, because this is a living person. This isn't a ghost. So fraud, they were undue influence maybe, definitely probably interference with contractual relations.
Depending, how hardcore you go with it, possibly assault.
Yeah, trespass if they're going on to property they don't own. I mean, there's legal ramifications there. Ghost and contracts questions. Given that Louisiana is based on French law, and that French law presumably has a lot of Catholic influence, are there any more interesting references to the rights, privileges, and duties of the supernatural written into law? Not to my knowledge.
Not to my knowledge either, but I do know a couple of exorcists, so I could ask.
Yeah, we do know an exorcist, don't we?
Yeah.
Holy shit, I'd forgotten we know an exorcist.
Well, I mean, one. I know 3, I think.
Why do you know so many exorcists?
I went to a Catholic college, and one of my cousins got certified online, so he doesn't really count.
Wait a second. There's an online school of exorcism?
Apparently so.
Like the DeFry Institute of Casting Out Demons?
Yes. He's apparently only done it once.
ITT Technical College and Seminary.
Yeah, it's get your TV VCR degree.
The University of Phoenix. You can learn to be a private investigator and get rid of those pesky demons. Cast them into a pig and send it into the ocean. That's the final.
That sounds like the way to become a real-life John Constantine. I'm into it.
And the head fox is asked, have there been incidents where someone has purchased property, then later claimed it to be haunted, wanted to be free of the contract, and successfully make the argument letting them get out of said contract? Head fox, we covered that. that is Stambovsky v. Ackley. Folks, once again, thank you for hanging with me. I am the Boozy Badger, Boozy Barrister. This has been Boozy's Legal Funhouse. My guest tonight has been Buddy Goodboy, Esquire, now a research attorney.
Thank you very much for having me. I really appreciate you having me on.
And we will be back next week with a discussion of life after death and what does that mean legally. If you want to support us, you can always do that over at patreon.com/lawyersandliquor. Get entry into the Discord where we read off your name at the $5 level and above every week. Discussions, ask questions, watch movies with us, play multiplayer games, and everything fun. If you don't want to do that, though, it's okay. You're always free to say, "Fat man, you're not getting my money. Just come back next time and I'll be waiting." Until then, I'm the Boozy Badger, Boozy Barrister. This has been episode 20 of Boozy's Legal Funhouse. You have a wonderful rest of your day. Okay.
All right. That was really fun. Thanks again for having me on.
Well, thanks for coming back. I always appreciate having people here for these.
Yeah, it's so much easier to have somebody to bounce off of. And sorry for the part in the middle where I had to get up and wrangle a coyote child.
You're fine. You're fine. Don't worry about it. The only reason I get to do it uninterrupted by my children is because my spouse and my older children are like, "Yeah, no, Dad's talking to the people on the internet. We can't disturb him right now." So.
Well, I had a fortunately clothed but wet child run into my room screaming.
That's the soundbite we end on.